This is the morning the architectural argument leaves the editorial pages. Over the span of 4 days, 6 independent stories from different branches of government began pointing in the exact same direction. The convergence is happening in 3 specific rooms: a civil courtroom in Santa Fe, a committee room in the Hart Senate office building in Washington, and a prosecutor's office in Tampa. For months, the debate to design mental health AI lived in journals and policy briefs. This morning, that argument lives in a bench trial and a federal committee report. Every one of these actions identifies the same winning standard: the supervised configuration. The boundaries are being drawn at the same place. The clinician owns the clinical decision. The AI does the work the clinician designates, and only that work. The transition from theory to enforcement has begun. As these cases move forward, developers face the reality that design choices involving autonomous output are now being reviewed under civil and criminal standards of liability. In Santa Fe, the second phase of State of New Mexico versus Meta Platforms opened this morning. The first phase concluded in March, with a jury finding Meta liable for misrepresenting platform safety to young users, resulting in a $375 million penalty. Now, Chief Judge Brian Beachside is hearing a bench trial to decide what Meta must actually do to remediate the harm the jury already found. He is being asked to translate that verdict into a product roadmap. The requested remedies include a 90-hour monthly cap, suspending overnight notifications, and rolling back end-to-end encryption for minors. Meta calls this infeasible, so the state is bringing engineers to testify on technical feasibility. In response, Meta warns it may withdraw Facebook, Instagram, and WhatsApp entirely. Beyond the courtroom, a parallel legislative wave is moving across the country. Oregon, Tennessee, Maine, Nebraska, and Iowa have all recently moved to codify AI constraints. The speed is significant. 4 of these laws were signed in just 31 days. Maine's legislative document 2082, signed by Governor Janet Mills, offers the clearest articulation of the new architecture. These laws share common requirements. First, a universal mandate for disclosure. The AI must identify itself as a machine. Second, they prohibit claiming professional credentials. In Maine, the law specifies that AI may not generate treatment plans or make independent therapeutic decisions without the review of a licensed professional. The operational takeaway for founders is one of efficiency. By building a product that fits this supervised architecture, a company can meet the compliance standards of multiple states with a single roadmap. This state-level pattern is now reflecting upward into the halls of the federal government. The Senate Judiciary Committee recently advanced the GUARD Act, a bill designed to regulate AI chatbots that simulate emotional or therapeutic interaction. The bill was introduced by Senators Josh Hawley and Richard Blumenthal, with a bipartisan group of original co-sponsors. The committee vote was 22-0. The bill mandates federal age verification and creates a criminal offense for deploying a chatbot that knowingly or recklessly encourages self-harm in minors. A unanimous committee vote carries institutional gravity. It signals that the move to criminalize the reckless disregard of safety guardrails has broad bipartisan support in Washington. While the GUARD Act moves through Congress, the first actual criminal investigation into an AI company has already launched in Tampa. Florida Attorney General James Uthmeier has issued criminal subpoenas to OpenAI following an investigation into a mass shooting at Florida State University. Prosecutors found that ChatGPT provided the shooter with tactical advice on weapons and campus population density. The Attorney General's framing was direct. If a person had given that advice, they would be charged with murder. The subpoenas break past the corporate entity. They are seeking organizational charts and the names of individual employees. Investigators are demanding internal training materials and safety protocols, looking for the specific documentation of design choices made by individual engineers. The platform defense is being tested by a state with criminal jurisdiction. Prosecutors are now reviewing the intent behind design choices, putting personal liability on the table for those who build these systems. All of these legal developments highlight a direct conflict between 2 completely incompatible product architectures. Google's bridge-to-support model for Gemini allows the AI to stay in the room during a crisis. It offers the user a crisis line, but the bot continues the engagement. Contrast that with the supervised model being written into law, which requires a hard stop, handing off to a human clinician. Maine's law mandates this side of the screen, prohibiting independent AI therapeutic decisions and requiring a licensed human to lead the intervention. This is a fundamental engineering choice. Developers must choose which architecture to implement, document that decision, and prepare to defend it against a growing body of state law. This convergence did not happen by accident. The architectural demands made by judges, senators, and prosecutors are based on a clinical record built by researchers over the past 18 months. These courtroom arguments have deep citation roots. The state laws we are seeing follow the clinical guidelines set by the American Psychological Association's 2024 advisory. The public nuisance theories in Santa Fe are supported by ethical frameworks from researchers at Brown University. These legal outcomes are the direct translation of peer-reviewed clinical evidence into a regulatory structure. This is a rare moment where evidence is translating into binding structure within 24 months of publication. For founders, the roadmap must now align with the clinical citations the courts are using. Enterprise buyers and their compliance teams are already using these standards for review. Diverging from the supervised architecture now invites parallel legal challenges from state and federal authorities. The adoption of this architecture is no longer theoretical. Today, that record is being put to work in courtrooms across the country.